morning, Your Honors.
Good morning.
Good morning.
May it please the Court, Tyler Daniels of the Putnam County Bar. I would like to reserve 3 minutes for rebuttal.
3 minutes, okay.
And I'm here today on behalf of the appellant father. And we're asking the court today to set aside the default termination in the Putnam County Chancery Court and remand the case back to the Chancery Court for a trial on the merits.
Well, let me ask you, it was a default determination, but then you had a hearing. So does the default really matter since there was a hearing?
Well, we did have a hearing to set aside the default.
You didn't go ahead and have a hearing and have the proof put on that there was clear and convincing proof that the
There was additional proof added to the record from the default hearing.
right.
I don't know that I had the opportunity to fully develop the record at that hearing, because my goal was to set it aside.
We're asking, though, about the hearing on February 28th, which was when the court granted the default. I mean, there was testimony, because the court references that.
Well, they initially
Said the sworn testimony of the petitioners in open court, the report of the GAL, counsel statement, arguments of father's counsel, made findings. So,
well, there wasn't really any argument on my behalf because my client wasn't there because I was unable to locate him.
right. But you had an opportunity to cross-examine the petitioners at that time.
I did.
Okay.
I had the opportunity, and it was a full opportunity. I'm not saying the court didn't
It's just
allow
a little
me.
tough when your
It's-
client's not there.
Exactly, Your Honor.
On the issue of default here, the default was issued not for failure to answer, but rather for failure to respond to discovery after a motion to compel, an order compelling responses had been entered. So in your request to set aside the default, was there any effort to make, to provide the responses that were missing, that were compelled? So,
There-
you know, Honor, here's our interrogatory answers, set aside the default?
There wasn't, Your Honor.
I mean, shouldn't that be a prerequisite to any relief from the default? If the default is based on a failure to act, should we at least expect the person wanting relief from that to say, okay, I have now done what the court has compelled?
Well, part of my motion to set it aside was a request for time to
For additional time? Okay,
responses.
so you wanted more time.
And I don't know if I put this in the record, but when I found my client, I met him in General Sessions Court, and immediately made an appointment with him and went and saw him, let him know the status of his case. That's when I filed my motion to set aside. He was in the Putnam County Jail, had limited access to him. That's why I requested more time to, set aside the default, let me respond to the discovery. So that's why it wasn't done on the front end.
Okay.
Because it was granted on February 28th, and I don't remember exactly the day I met him, but within 30 days I had my motion filed. So I just had limited time to provide those responses. I'm sorry. So the grounds for termination were abandonment on failure to visit and failure to support. And in part of this, my client was served while he was incarcerated. He filed his own written response. Once he was released, he went to the clerk's office, filled out the paperwork to get appointed counsel. He was appointed counsel on March 10th, 2023, and then the case sat dormant until March 1st of 2024. Nothing was done by the petitioners. Nothing was done by my client or his counsel. And at that point, his counsel requested to withdraw. He moved on, took a position with the public defender's office, and that's when I was appointed. And received the discovery request, and then nothing really happened until February 28th, 2025, when we had the motions for sanctions. We're requesting the relief today from the default judgment. We just want to go back and have a full trial. And for that, we have to show that the respondent's behavior was not willful. And the court's consistently held that willfulness, deliberate choices amounts to willful conduct. And I don't mean to go back into this, but here my client filed his own response. He went to the clerk's office of his own accord to get appointed counsel. And then I think he just got lost. I mean, nothing was happening with his case. No one apparently was working on it. He just got lost. And then, upon me finding him and meeting with him and him learning the status of his case, almost immediately he took action to have the default set aside. I think those are deliberate choices that show that the default was not willful. After that,
Counsel, what's the meritorious defense here that your client would offer? And and your client seems to have not visited, client seems to have not paid for support. What's the meritorious defense here that would be offered, that if there was to be a further hearing, what's the evidence that we're missing?
yes, Your Honor. As to the failure to visit, the uncontradicted proof shows that visitation stopped in May 2021. However, this child was born in 2011, so he would have been around 10 years old at the time, 9. His birthday's in September. So he was visiting up until that point, and my opponent in their brief argues that the mother had no legal obligation to provide visitation, and I don't disagree with that, but she had been providing visitation for almost 9 years until he was arrested at a traffic stop. And at that point, she said, you can't visit anymore until you get a clean drug screen. But there's no proof in the record of that traffic stop or that he was found guilty of any drug use. So I don't think that is willful. I do understand that he has an obligation himself to, he could have came to court and filed for visitation, and he didn't, but he had never had to for 9 years previously. And as for the failure to support, fortunately my client has been incarcerated, and that's why my argument about the determinative period was in there. And I know incarceration doesn't relieve him from the obligation to provide support, but it could explain that his failure to pay support was not willful.
Would you agree that with opposing counsel, that the determinative time period was from February 2022 through June 2022?
I meant to look at that and calculate that. I don't disagree with it right now, but I'm not sure. And just to hit on prejudice real quick, this case sat dormant for nearly a year. As far as timeliness, nothing was timely done about this case. I understand my opponent's argument that his clients will incur additional fees and things, but as far as being prejudiced by time, I think they waived that argument. With my remaining time, I just want to address the award of attorney's fees, or that requested by my opponent. Courts consistently held that a parent's right to the care and custody of their child is among the oldest and of the judicially recognized fundamental liberty interests protected by the due process clauses. And the courts also, as far as the statute for the award of attorney's fees, they construe that strictly. They construe that section of the code strictly to not discourage appeals. And further, the determination of whether a parent's rights to his or her child should be terminated is the most serious and grave issue to be addressed by this court. Accordingly, we are loath to consider an appeal of a trial court's judgment terminating a parent's rights to be frivolous. Here, my client, he's at risk of having his parental rights terminated forever. So, therefore, his request for this court to review the trial court's findings is not frivolous or just done to cause undue delay. Therefore, we're just asking that the court set aside the default and remand this back to the Chancery Court. Thank you.
Thank you.
Good morning, Your Honors.
Good morning.
Please the court, I'm Michael Weston from the Putnam County Bar. I represent the petitioners of Parkers who are present today. Also here today is the garden ad litem attorney, Lacey Highland is here as well. So first, I suppose the council kind of got into a little bit. It was a default granted for the father's failure to respond to the discovery. And of course, at the time the petition was filed, he was in jail. He got out after that, and I think he testified to some of that. He was out for a while. But even as of when Mr. Daniels was appointed, there was an order entered. It's in the record on, looks like it's page 17 of the appellate record. Respondent's counsel of record, Matthew Tyler Daniels, was served the discovery request April 17th of 2024. As of October 8th, 2024, respondent has not responded to written discovery request nor responded to his counsel of record after his counsel of record attempted to communicate with him regarding the request. So Mr. Daniels is trying to communicate with this guy for this whole time. So there's a lot of this, well, it's delayed. And the challenge that we run into on our end, and the trial courts too, is when you have these where someone does just a little bit and then they're not, is we run into, okay, so what do I do with this? If I go file a default, and then day 50 he comes in with some excuse and the court gives him. So it's always kind of that back and forth. So as the chancellor found at the hearing on the motion to set aside, that time didn't hurt him at all. And actually, it could have helped him maybe if he would have chose to, got his life together and done some things. It could have actually helped his position. But having that delay there, while it's not what we like to do, Unfortunately, it does happen and didn't prejudice him any. But his counsel is trying to get a hold of him throughout this time. So from April of 24, the default hearing was in February 25. And at that time, Mr. Daniels tells the court, I've done diligent searches. I've Facebooked, I've looked, I've sent letters to every address I can think of. And me and Mr. Daniels work both together and against each other a lot. And I can, sit here and tell all of y'all, if he told the chancellor that, he's telling the truth, and he made that effort. So what really happened is, all of this time that goes by, and there was some testimony put on that with Mr. Reed's testimony at that set-aside hearing, he's got warrants out for his arrest. So he's not going to show up to court on this TPR. The only time he finally is active is when counsel happens to see him in Sessions Court on his criminal charges after he got arrested again. Then once he's in jail again and has nothing to lose, now we want to fight this and we want to do something.
Counsel, I have a question for you about the determinative period with regard to the termination grounds.
Yes, sir.
In your brief, you state, based on the exhibits, the respondent was incarcerated from June 17, 2022 until February 26, 2023. So the determinative 4-month period would be February 2022 through June 2022. I didn't see a citation, though, specifically, and you said sort of exhibits generically. Where in the exhibits are you taking the incarceration dates of June 17, 2022 through February 26, 2023 from? Where did you pull those dates from?
I don't have that exhibit in front of me, but off my head, I believe that was in Exhibit 2. There was, one of the exhibits has the
I'm looking at
report dates.
I'm looking at Exhibit 2 right now, and this has to do, it's dated April 24th, 2024, and it has to do with the father's attempt to falsify a drug screen. It refers to the father reporting for intake on March 7th, 2023, but it tells me nothing about his incarceration during the period of the petition to terminate was filed. I don't know from this order, I mean, as you know, whether the parent challenges the grounds or not, we've got to review all of them closely. This is the first judgment I've ever seen that didn't identify the relevant period of abandonment. It just says the relevant period. There's no dates whatsoever. I mean, why isn't that enough alone to reverse this?
Oh, yes, Your Honor. I don't think that's enough to reverse it, and here's why. I understand your point, and very well that could be a reason to in certain cases, but here, undisputed testimony from everyone, including Mr. Reed, he had no contact from May 2021 until the day we were in court. He hadn't paid any support. I think he might have argued the support.
But for all we know, though, he could have been incarcerated from May 12th.
Well, that's where I was going, Your Honor. So his own testimony was he was out for a 13-month period getting paid under the table. So when the chancellor made that finding, his point was it's been so long and there's been so many periods of time that he was out that that's not
But that finding's not in the order, though. I mean,
well, the
so-
finding that he's not had contact since May of
it
2021.
is in there, but not about his periods of incarceration. If you're going to rely on that definition of abandonment, doesn't the court at the very least have to make a finding of when the parent was incarcerated?
Well, I think in the situation where there was that length of absence and he was not ever in jail for that long of a time, that it's already,
Yeah,
it's
but
kind
we don't-
of, it's kind of like us arguing
know
is
that.
the sun outside today and it's daylight. We know
Right,
that's.
but we don't know that. I mean, we've got to look at this order and check the factual findings and make sure that each factual finding together constitutes clear and convincing evidence of the ground. Can we say that with this judgment?
I think you can, Your Honor, because the
How do
father himself
show
says,
me how I put that together.
Well, that's
because with looking at the order.
because you have a 4-year period of time that he is not doing anything.
The court finds when the petition was filed. The
And
court
in that
lets us
four-
know they're relying on the definition of abandoned by an incarcerated parent. And then the court finds father did not visit with the minor child in the relevant 4-month period of non-incarceration immediate preceding the filing of the verified petition to terminate parental rights, having last seen the minor child in this action in May of 2021. And then it says, see Exhibit 2, which again is the exhibit dealing with a drug test that happened well after the petition was filed.
And I apologize, I don't have it in front of me. My recollection, one of those exhibits specifically had report dates and when he was in jail.
Well,
And there
that,
is
that exhibit
time.
has a report date, but the report date is after the petition date. The report date, father reported for intake March 7, 2023. I mean, they're just, this is of all the termination judgments I've seen, this has the least amount of findings to support the grounds.
Your Honor, I apologize, but I have to respectfully disagree with that. I think you've got that 4-year period, and it's not like he's in jail for 2 years or 3 years. He's in jail for a few months, and he's out of jail. He's admitted, I've done nothing for that 4-year period.
Counsel,
So the exact technicality of when was his operative period is
The
not.
13-month period you're talking about in terms of the testimony. So you're saying he testified that he was out for 13 months. Is the testimony clear that that 13 months is between whatever month it was in 2021 and the date of the filing of the petition? So the date that of his that he stops visitation on date, is it clear from the testimony that that 13 months is pre-petition filing? Or does he just say, I was out 13 months?
I'm not 100% sure on that.
Okay.
But where he's not in jail for just this long period, I submit that while it doesn't sound good, it's not the reason the chancellor didn't go and say this date like we do in a lot of cases was because it was just so blatantly obvious, at least it was to him. And I do understand what you're saying, but I don't think
it would
that's
be,
enough to-
so it would be a different case had the court not relied on the definition of abandonment for an incarcerated parent. Because of that, that becomes important to know the dates of incarceration. If it had just been the straight definition of abandonment, non-incarcerated parent, yes, I agree with you. May 21 to a finding when the petition was filed gives you more than enough dates. But it's the fact that it's an incarcerated parent means the dates are really crucial for us to review this.
Again, I understand what you're saying, Your Honor, but with the amount of, we're talking years here is why I think.
Okay.
I don't think that's a issue. I think the time is there. I suppose, yeah, we could remand it down for that finding, which is just another financial hurdle for my clients to have to pay, and then he gets a free ride.
Well,
again.
and
But
sort
we're
of,
gonna
the
be
court is
right
aware
back
of
here
that,
again.
but I mean, we're dealing with a constitutional right here. I mean, we can't just, as a matter of expense, say, well, we're just going to ignore constitutional rights, can we?
Well, I understand. We're also dealing with a 14-year-old child who, to this day, was never a parentage action filed, and I believe even yesterday.
And that
asked
could
the
have been
question of-
that could have been another ground for,
and
but it wasn't asserted, so.
Well, I
Yeah.
wasn't on the case at that
Yeah.
point, but I do acknowledge that. But he had enough time to be out that I think that period is covered. I'm happy to look back at that exhibit and see if we can pinpoint those dates and address that however the court wants to. But, and then of course regarding the opposing counsel talking about the willfulness, he did take some effort to begin with, but the willfulness, deliberate actions and actions to not follow up with your counsel and to not help with the case, you can't do that. I've been in his position, and it's not a fun position to be in when you have especially on a termination, when you have a client who you can't find or you can get a hold of them sporadically. But he chose to not be checking in with his counsel and he's made those deliberate efforts. And like I said, he testified he got paid under the table. There was a child support order down. The court also found that he wasn't paying that support.
A lack of willfulness is a affirmative defense, isn't it?
It is affirmative defense, but you also got to raise it in your answer. There is
Right.
references to
And
a
the
hand
answer's been
rope.
struck.
I'm sorry.
And the answer's been struck.
It's been struck, 1, and 2, I never even saw it. There's talk about that he filed a pro se answer. I never laid eyes on it. I highly doubt it had an affirmative defense, but to your point, it was struck as well. But I believe that for those reasons, we ask that it be affirmed. I think there's enough there. I think that the chancellor, like you had mentioned, well, you kind of did have a hearing, and that's one thing in our area I think is a good thing versus some other areas I practice in where they go through, even with a default, put on testimony and try to develop the record. So with the proof that was there, and then I think on top of that with Mr. Reed's testimony, he was probably our best witness himself.
Has there at any point been any sort of offer of what evidence would have been presented or argument would have been presented if there hadn't been a default here? And this is an unusual context, right, with a default when you're talking about a parental termination. Has there at any point been any type of assertion of, well, if we hadn't had the default, we would have been able to do X? Or is there essentially no injury here in terms of a default, given the context of the parental termination case where you have to have the evidence anyway presented to determine grounds?
Right. So when you say there's no injury, I'm not
So
sure I understand.
in terms of the default here, has there at any point been any kind of showing as to what would have been presented in the absence of a default? I'm trying to figure out the harm here.
Well, that's my point is I don't think there's no harm because the way we do it in my home district is we usually have to at least put some proof on instead of it just being default granted. And
right. And is there any showing here of any harm?
there's not. Counsel's there had the opportunity to cross-examine. I mean, the only thing he didn't have was his assistance from his client, which is.
And there's been no showing of what a client being present and offering assistance would have done.
Right, and he testified at that April hearing anyway, and like I said, I think he was probably our best witness to what he was presenting. So we would ask, I'm happy to answer any other questions you have, but we would ask that the order be affirmed.
Thank you.
Thank you.
Just quickly, Your Honors, to clarify something. When Father's original counsel withdrew, the clerk sent notice to the petitioner's counsel at the time and the Father's counsel. It was just notice sent to the attorneys to appear for the status of the case. And at that point, it was Mr. Hargis was his original attorney, had an oral motion to withdraw. So my client wasn't there at that hearing. He didn't know his counsel was withdrawing. And at that time, he did not know that I had been appointed as new counsel. And I just wanted to bring that up, just to go towards willfulness. As far as, nothing happened for a year, then his counsel withdrew. He was not noticed to be at that hearing, and I believe that's in the record. So he had no notice that he received new counsel. There was a finding that he knew to go back to the clerk's office, or that he should have done more. I don't know what more he could have done. I mean, he knew the termination was pending, but then nothing happened, and his original counsel withdrew, limited contact with that counsel, if any, and then I was appointed, and now we're almost 3 years down the road. And it was definitely at least 2 years before he met me. So I just wanted to bring that up as
Counsel, with regard to the dates question here and the determinative period, would you agree that if there is an error in that regard, that the appropriate remedy would be to remand for the trial court to determine what the dates were of incarceration and specify whether and what the trial court's finding is on that?
I do, Your Honor, and we briefly touched on it in my original argument, especially as it goes to failure to support, and it feels wrong saying this up here, but during the period of 2021 to the filing of this, my client had some significant legal issues, and he was incarcerated several times. So I think it needs to be remanded to determine whether he was incarcerated during the relevant periods. And thank you all. That's my time.
Thank you. Thank you both. That concludes the morning docket. Would you please recess court until this afternoon?